order and ask Director Board Member Landry to do our pledge.
Please rise. Put your right hand over your heart. Ready, begin.
Pledge allegiance to the flag
the States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And some of you may know this, but one of our really important members of our community and in water world passed away over the last few days. Vince Dino, who has been to many of our meetings, friends to many of us, and it is a huge loss to our community. I would like to take about a minute of silence to recognize Vince and his family and to send prayers and condolences their way. Thank you, everybody. And again, keep the family in our thoughts. And for the board members, we do, and any members of the public, we do have a card that we're all going to fill out. And if any of you would like to be part of that, we will keep it for you, but all of our board members will do that and staff if we would like. Okay. Thank you. Roll call, please.
Director McLaren? Director Hernandez?
here.
Director Calandry?
Here.
Director Martin?
Here.
And Director Martin is on the line, by the way. Director Paris?
Here.
Peter Thompson?
Here.
Arden Wells?
Here.
Is Craig on the line?
Yes, and I'm here.
Okay, and we also have Cameron Goodman present. And then are there any other alternates on the line?
Good morning, this is Rami Gandhi, alternate for District 40.
Thank you, Ron.
Barbara, I'm here too. Barbara for Kathy.
Audrey Miller for Rob Paris. Okay. All present.
Great, thank you. We're now on item 4, adoption of the agenda. Is there a motion to adopt the agenda? Motion made by Kathy,
Second.
second by Carolina. Is there any discussion? Hearing no discussion, all in favor of the motion by roll call vote?
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandry?
Yes.
Director Martin?
Yes.
Director Paris?
Yes. Motion's carried unanimously. We're now on public comments on non-agenda items. Public, come forward, Benny, and just say your full name and please speak.
Yes, my name is Benny Moore. I feel like I had to say something here. To whom it may concern, my name is Benny Moore. I would like to say I have been coming to these meetings for quite a number of years, and I've tried to find out what the laws and regulations of the adjudication and the water laws are. And I've been taken to court by this tribunal, the WATERMASTER Board and what have you, although I've been trying to come before them and work out what I had for as water rights with them, which they refuse to seem to hear. They've taken me to court, and their attorney has, although I've gave him all types of documentation so far, and it's still in court, that documentation that shows these rights, this board has refused to acknowledge it. So it's still going into court, and I just had to stay up and say something. And I just don't think this board is doing its job. And I've heard that from professors from up north, and I'm talking to people to try to get this straightened out. And the board refused to hear my thing. And their attorney, Craig Parton, And I guess the board also that says that I'm some scammer. He says that although this is public, so that's the reason why I'm saying it out and I want everybody to hear it. It's public, that I'm a scammer that's presented a bunch of scribbled papers from the Bureau of Land Management. And I just had to get this out and say it. And actually, I'm starting to feel like you guys might as well just burn a cross on my lawn. That's how far this is getting. This board has refused to hear and ask for the documentation and see the documentation. Every time I asked the board about it, can you talk to an attorney? His deal is to just demean a person and prove that they're wrong and say that they're wrong. So I just had to get that out. My name is Benny Moore. If anyone has any, I'm getting calls from people that saying they've read the papers that he wrote and they're demeaning a person. To say he's lying. I know it's in court and that's a lawyer's job, is to make a person look bad on the other end. I'm not lying. Everything is documented and it's the truth. If anybody has anything to say, at Mo's, M-O-S, waterstation@AOL.com. Thank you very much, and thank you for your time.
Benny, thank you. Any other public comment? Okay, that brings us to the consent agenda, and that's consent agenda items A, B, C. And is there a motion to approve the consent agenda?
So moved.
Motion made by Carolina, second by Kathy. And Peter, anything you want to point out?
There's not anything unusual about this consent agenda, but we're happy to answer any questions.
Okay, great. Any questions of our administrator? From the board, from the public? Hearing none? All in favor of approving the consent agenda by roll call vote?
Director McLaren?
Yes.
Director Hernandez? Aye. Director Calandri?
Yes.
Director Recca? I'm sorry. Director Martin?
Yes.
And Director Paris?
Yes, motion
Thanks
is
for
carried
that.
unanimously. Thank you. Now we're on the advisory committee report. Dennis? Oh, that's right. Dan, are you online?
Yes, sir. Good morning, Chair Paris. Can you hear me?
I hear you very well.
Perfect. Okay. The summary of the advisory committee report has been included in the board's packet and has been there for your review. I can answer any specific questions that the report may have generated. I have been asked to draw special attention to the discussion regarding items requested at the June 18, 2025 meeting. That was our meeting as it relates to information being provided by the General Counsel to the public. There was a robust discussion in terms of what can and cannot be reported out of meetings because of the attorney-client privilege issue that exists. But there was a request that the board consider pushing out additional information when dealing with, for example, the potential sale of properties in order to satisfy a judgment. Specifically, some board members were commenting that they had been specifically contacted by potential buyers of properties that were being sold to satisfy the judgment, and that it was their understanding that those buyers, if they had been made aware of the process earlier, could have potentially submitted higher and better bids for that property. So I think that in summary, the request is just get greater transparency on the procedural process so that better bids could be considered by the board. So that would wrap up the sum and summary of my report. If there's any questions, I can certainly entertain those and try and provide a response.
Great. Thank you very much for your report. And I think I will have, I know Cameron is here and Craig's on the line. And I was listening to the advisory committee too, and I heard the same comments. So if Craig or Cameron, do you want to take this up in your attorney's report, or would you like to respond to it now? Whatever.
I think now is a good time to respond. And Cameron and I have discussed this, and I'll let him comment and follow up with anything I think necessary.
Great, thank you.
Sure, thank you. So the strategy here is that the advisory committee is referring to the settlement negotiations that have been ongoing between Rancho Sierra Properties and the WATERMASTER to satisfy a money judgment that the WATERMASTER has obtained against Rancho Sierra Properties. Those were confidential settlement negotiations related to pending litigation that went on for some time. Over the course of those negotiations, eventually the city of Lancaster became involved because they were interested in acquiring the property, and a three-way deal was outlined. In April, General Counsel, Mr. Parton, made an announcement during public session about the general concept of the deal, the parties involved, and the then most current highest bid or offered to buy the property, which at that time was by the city of Lancaster, and stated on the record that the WATERMASTER would consider any higher offers to potentially incorporate into the settlement discussion. After that time period, by the May meeting, nobody had contacted the WATERMASTER to our knowledge. So the WATERMASTER has continued down the path of settlement negotiations with the highest bidder.
And Craig, do you have anything to add?
No, it's somewhat frustrating to us, I think, in that we've attempted to be as public and transparent on this issue as we can. We've done this in open session and have made available the WATERMASTER for answering questions and entertaining higher bids. And we heard nothing. So we think this is the best result for the WATERMASTER. It's a somewhat complicated transaction, but we're going forward with it, and appreciate the advisory committee's comments on it. But our effort has been to be as forthright as we can. We revealed what the bids were, and then solicited more comment after that and received none. So that's my follow-up to Mr. Goodman's comments. Thanks.
Yeah, and I'm not sure it was mentioned, but correctly if I'm wrong, there was an appraisal done on the property. There were two bids, or I guess a third bid on the property. The bids were at or above the appraisal price. And this, I know in the advisory committee that I listened to, there was concern like this should have been a sheriff's sale. We should have had open bidding, and this was a different transaction than that. If the two of you could comment on those points, I think it'd be good for the public to hear comment on those points.
Sure. Thank you, Chair Paris. I can comment briefly that it was General Counsel's opinion early on in this process that the time and expense and uncertainty associated with the sheriff's sale, which would otherwise be the process for liquidating this asset to satisfy the judgment against Rancho Sierra Properties, was outweighed by the benefit of getting to the end result with more certainty quicker through a private settlement with a potential buyer, which in this case, the highest offer has been submitted by City of Lancaster, although you are correct, there was another offer submitted by a private party who did not then submit an offer higher than the City of Lancaster's current offer.
And I just want to correct myself. My legal advisor made me aware I misspoke. It wasn't a bid, they were offers, so thank you.
And Cameron, gotta word this carefully. The way you're saying this, it could be interpreted that we administered the sale of that property.
Correct. I think the nomenclature is an offer by a third party to be a part of a private settlement with Rancho Sierra. The WATERMASTER is not engaging in an open bid process. If we were to go down that route, it would be by way of a sheriff's sale, which is governed by statute and certain procedures, and it's time consuming and costly, and the end result is uncertain. So because there is a offer above what is the appraised value for the property, the WATERMASTER General Counsel has recommended to the board to pursue this private settlement route, which includes a third party other than Rancho Sierra making an offer for property.
And just, this is rhetorical, but I want to hear you say it. Did the WATERMASTER at any time ever have ownership of Rancho Sierra property?
No, the WATERMASTER is not a fee title owner of the Rancho Sierra property. The WATERMASTER has a judgment lien recorded against the property, and that is what the WATERMASTER is seeking to enforce by way of this settlement.
Thank you for those
Questions
clarifications.
that I've been asking. Trying to
No, I appreciate
add
that.
some clarity.
Yeah.
I couldn't comment.
Any other board comments or public comments? Okay, thank you. Dan, anything else?
No, Chair Paris, that would conclude my report, other than I can respond to any specific questions that the directors may have.
Super, great. Thank you.
You're welcome. Thank you.
Hey, Rob?
Yes. Who is this?
This is Galen Kyle.
Hi, Galen.
I was wondering who did the assessment on the value.
Galen, you broke up. Did you ask who did the appraisal?
Yes.
I don't have that in front of me. If Mr. Parton's in front of a computer, he could pick up the name of the appraiser that was retained.
Yeah, it was a local appraiser that was well known to some board members. See if I can find it. I'll get you that information during the course of the call. But it was a appraiser known to a number of people, and was of solid reputation as far as we understood their qualifications.
Great. So you'll make sure Mr. Kyle gets that.
Absolutely.
And Craig, maybe you can have that information during your attorney's report, if possible.
Yeah.
That'd be great. Thank you for the question, Galen. Any other questions from the public? From the board? Okay, that brings us to item 8. And we're going to, I'm sorry, is there somebody on that had a question? No. Okay, we're on item 8, public hearing to consider 2024 draft annual report for the Antelope Valley WATERMASTER. And I need a motion to open the public hearing.
Motion?
Motion made by Kathy, she beat you to it, Angelica.
Second?
Yes, thank you.
Perfect, thanks.
So motion made by Kathy, second by Angelica to open the public hearing by roll call vote.
Director McLaren? Director Hernandez?
Yes.
Director Calandri?
Yes.
Director Martin?
Yes.
Director Paris?
Yes, motion's carried unanimously. Now we're on presentation and statements by the engineer. Arden, it's your show.
Thank you. Good morning. So I'm going to share my screen real quick. And and oops. All right, can y'all see this A-okay?
Yes.
Okay, great. So this is the public hearing to approve the final or the revised draft of the annual report so we can turn it into the final draft. And this is due to both DWR and the court by August 1st. So a few summaries of updates that we made to the revised draft from the initial to the revised based on our discussions last month and comments that we received. So we updated some of the wording in response to comments, and we included some more detail about the relationship between native safe yield and the water balance section, as well as discharge into the adjacent basins. However, we will really take the time to dig in and provide more details on this in next year's annual report. And then we also, in the tables of the sub-area water balance, before we had it from 2020 to 2024, and we reformatted it to extend that period from 2016 through 2024 in the revised annual report. So those are the big changes from the initial to the revised drafts. I wanted to real quick just briefly present the last remaining pieces of the data in the annual report as part of sort of the 3-part presentation series. So this slide is showing the map to the left of annual land subsidence in 2024. And so the yellow being shown shows a negative vertical displacement of up to 1/10 of an inch. But that goes from 0 to 1/10 of the inch. And there is a range of error for the overall subsidence. And I want to contrast this with last year to the right, where we have the vertical displacement. Last year was showing over most of the basin a positive vertical displacement. So my interpretation of this year's annual land subsidence is that while we see negative subsidence everywhere, this is a bit of a response likely within the range of error of an overall, not a significant change in most of the basin, recognizing that last year there was a little bit of an increase detected. This year, largely for most of the basin, it's balancing out. But I want to put that in context with the cumulative subsidence in the basin since 2015. And so this is really where we see where cumulative impacts have occurred. Overall, this figure is not different from what we saw last year. We see in some of the areas with the most pronounced subsidence up to a little bit less than 5 inches of total subsidence since 2015. And I want to emphasize that this also includes the ramp down period. And some of the subsidence may be in delays from prior to the implementation of the adjudication. Some of impacts from the pumping before ramp down occurred. Do y'all have any questions about subsidence? Hearing none, moving on. Oh, yes.
Yeah, I do have a question,
Okay, great.
just for the public's education. When you talk about subsidence, you know, we often hear about subsidence in the Central Valley and how it's impacting our aqueduct and impacting people's wells and things like that. So it can be a scary word. Subsidence in the Antelope Valley, as far as I know, has had no impact on things like that because it's not near as bad as the Central Valley in certain areas. So I'd just like you to comment on, are you, as our engineer and as the WATERMASTER board, is there action that you think we need to take because of what this report is showing, or are we doing everything we need to be doing at this point?
At this time, there's no action to take for subsidence. We see that the rate of subsidence has slowed significantly since the implementation of the judgment. And we do keep in mind when we do material injury analyses, the areas that are prone to subsidence, either because they're geologically prone, because they have thick clay layers, or because we see long-term lowering of groundwater level trends. We're very careful to make sure that those vulnerable areas are factored into the material injury analyses, and we aren't increasing drawdown significantly in those areas.
Okay, thank you. Other questions, comments? Okay, Arden, appreciate that.
Thank you. The last brief update of the data I want to provide from the annual report is just noting that the total volume of carryover water in the basin continues to grow year to year. At this point, the total amount of accrued carryover water is about 270,000 acre feet. In contrast, the native safe yield is 82,300 acre feet per year. And this is one of the figures in the annual report where we break down the total carryover water by year, by sub area. Are there any questions about this?
Board, any questions? Public, any questions? Okay, no, Arden, go ahead.
Okay, thank you. So I also want to just note, we did receive a few additional comments since the revised draft was posted. And we do plan to include these in the final draft of the annual report. The first one were a few edits to Appendix C, which is the storage of carryover water. These were from AVEC, and this was just to update the numbers for the accounting for water that was imported but used outside of the basin. And we also updated the text to correspond with those updates. And then we added some language that clarifies in the carryover section the difference between carryover from production right and in lieu water that is used in the judgment. So I want to highlight these and just see if there are any questions about these or if y'all would like us to expound a little bit more.
Any questions of Arden on this from the public?
Arden, I do have one question, if I may. I want to go back one. You said you have the carryover tracked by sub area, correct? How'd you do that? If you guys don't have the beginning bounces in the sub area, how are you able to get the numbers? I'm a little confused.
So these numbers are, so one of the assumptions that's built into this is that we use the locations of wells and the proportions of carryover by wells just based off of production from this past year. So there are some assumptions baked in here that going back to 2017, it's more of an estimate than the exact volume of carryover broken down by each well.
Okay, thank you.
You're welcome.
Okay, any other questions? Go ahead, Arden.
That sums up, that sums up our slides for and presentation for the annual report. And so just want to open it up for any additional questions or comments.
Are there any questions of Arden regarding the annual report? Any questions from the public? No questions, Arden. Next, we're open for statement or comments by the advisory committee. Dan, I can read your minutes if that will help you, where it says there were no comments or questions on the report from the advisory committee. Dan, do you have anything else to add? If you're still here.
I think he's gone.
Okay.
He's on.
Oh, he is.
Oh, he is? Okay. Any?
I'm on, sorry, I got muted. Nothing further, Chair Pierce. Thank you.
Great. Thank you, Dan. I appreciate it. Now we're statements by the public. Any comments or statements by the public? And we show any hands? Okay, we're getting ready to close the public hearing. So going once, going twice. Do I have a motion to close the public hearing?
So
Motion, Angelica.
Well, Angelica,
ladies first.
Brandon said lady first, so you get the motion to close and Brandon will get the second.
Thank you.
Was neck and neck. Any discussion on closing public session? Hearing none, all in favor of closing the public hearing, excuse me, I said session. You gotta correct me, Brandon. Public hearing by roll call vote.
Director McLaren? Director Hernandez?
Yes.
Director Calandri?
Yes.
Director Martin?
Yes.
And Director Paris?
Yes. Motion's carried unanimously. Public hearing is closed. And that brings us to item 9, consideration possible action to approve the 2024 draft annual report of the Antelope Valley. And Angelica, I'm going to ask for a motion to approve resolution R2534. Would you like to make that motion?
Motion to approve.
Okay. Is there a second?
I'll second.
Second by Carolina. Motion made by Angelica, second by Carolina to adopt resolution number R2534, approving the 2024 annual report of the Antelope Valley WATERMASTER. Any further discussion? Hearing no further discussion, all in favor of the motion to approve resolution R2534 by roll call vote.
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandri?
Yes.
Director Martin?
Yes.
Director Paris?
Yes. Motion's carried unanimously. We're now on item 10, presentation of 2025 second quarter year-to-date budget versus actual budget. I think this is going to be given to us by Teresa.
Chair
Go.
Paris, can I make a comment? This is Craig Parton.
Sure, Craig.
Just wanted to note that council will prepare the annual report for submission to the court by the August 1st deadline under the judgment, just so you know that that piece will be done. Thank you.
Super. Thank you very much. We never doubted you. Okay. Go ahead, Teresa.
This is the budget report for the second quarter. And the staff report for this is on page 39 of your packet. The budget versus actual report is on page 40, and the cash flow report is on page 41. So looking at the budget versus actual report, the first column is the 2025 budget. The second column is the revenues billed and expenses incurred through June 30th. And the third column is the percent of actual to the budget. So if revenues and expenses were spread evenly over the year, we would expect to be at 50%. So overall, the actuals are in line with the budget. And we'll just walk through and note a couple of things here. So most of the revenues have been billed for the year. All of the assessments have been billed. There will be some additional application fees as they come in and some late fees that will be assessed August 1st. And the known small pumper assessments that went out this year are still coming in. So total revenue is just over $1 million, which is 99% of the budgeted revenue, and 88% of that has been received. And moving to expenses, just to note, this doesn't include a June invoice for legal services, and it doesn't include the second quarter invoice for the USGS contract. And you'll see that as we get to those items. So the administrator services is at 25%, and that's because a different administrator was budgeted for, so we're well under that. Legal services, that's at 38%, and again, the June invoice wasn't included in this. So if we had received it, we'd be closer to the 50%. WATERMASTER engineers at 76% of the budgeted amount, and that's due to the annual report being in the middle of the year. So USGS, again, that second quarter invoice wasn't received. So if we had received it in time, it would have been at 50%. The general liability insurance. So last quarter, the board questioned that it was at 117%. Well, we did receive a refund of $2,870 for being overbilled. So they provided a refund for that. So that's really at 65% for the year.
Great, thank you.
Yeah. And then the postage is a little higher. Those small pumper invoices went out. So we had to get postage for that, and that was not budgeted for. The audit is at 97%, but that's done for the year, so that's the whole year. And the website maintenance and email addresses, that includes invoices for the whole year for that. So that's the year's amount. So about 45%, so well under what was budgeted, and it looks pretty good. And I'd be happy to answer any questions.
Very uplifting report, Teresa.
Good.
Any questions from the board?
I just want, oh, sorry, go ahead. Yeah, you first, please. Okay, sorry. I just wanted clarity if you could share. I know that I wanted to be clear. Some of these, we anticipate a later billing. So while we're at 45%, are you indicating that we anticipate that that would climb in the next month or so,
Yes.
quarter?
Yeah, so well, if we would have had a June invoice, the average of the legal is about 23,000. So that would have been closer to 46%. And if we would have had the USGS, it would have been at 50%. So if both of those invoices were included, we would have been at 49%. So right at the 50% target.
Okay.
Does that answer your question?
Yes.
Yes. Okay.
Any other questions? Any questions from the public? Excellent. Thank you very much, Teresa. That brings us to item 11, consideration possible action on small pumper qualifying documentation. And that's going to be our administrator. Angel, go Angel.
Thank you, Rob. We have one small pumper qualifying application on this month's agenda. The application starts on page 43 of your agenda packet. This is for John Kigagas, and the parcel is located in the southeast sub-area. Based on the documentation provided, this parcel does qualify as a small pumper parcel. The well was drilled in 1979, concurrent with the construction of the house, and was solely used for domestic use to supply the household. The advisory committee and staff both recommend approval for this application, and I am happy to answer any questions.
Any questions of Angel? And is there a motion to approve resolution R2535?
So moved.
Motion made by Kathy. Seconded by going once, going twice.
I'll second.
By Carolina. Any discussion? Hearing no discussion, all in favor of the motion to approve resolution R2535, 35 by roll call vote.
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandry?
Yes.
Director Martin?
Yes.
Director Paris?
Yes, motion's carried unanimously. Now we're on item 12, consideration possible action on replacement well application. Oops, same, different application. Okay, so that will be Angel again.
Yeah, thank you, Rob.
Got me confused.
I
Angel.
know. We have one replacement well application on this month's agenda. It starts on page 58 of your agenda packet. This application is for John Kagigas. He is a qualified small pumper. The request for this replacement well results from the existing well going dry in the summer months, producing little to no water. He does plan to cap the existing well once the new well's constructed. And the advisory committee and staff both recommend approval of this application, and I am happy to answer any questions.
Any questions, board? Any questions, public? Hearing no questions, is there a motion to approve resolution R2536? Motion made by Kathy, second by Brandon.
Second.
Oh, Brandon. Being your partner.
Just in a different manner.
Great. Okay, motion made and second. Is there any discussion? All in favor of the motion by roll call vote?
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandry?
Yes.
Director Martin?
Yes.
And Director Paris?
Yes, motion's carried unanimously. We're now on item 13, consideration possible action on transfer applications, and that will be Arden.
Hi, good morning. So the first transfer application today is for a one-time transfer from AVAC to LA County Waterworks District 40. And this is a one-time transfer of a little under 2,700 acre feet. And so annual transfers have occurred from AVAC to District 40 since 2020. And the two parties entered into an agreement for the lease of overlying production rights for the transfer of AVAC production rights to District 40. And so this transfer is to fulfill lease obligations. At this time, LA County Waterworks does not intend to use this water. In 2021 and 2022, we talked with some staff and they said that the wells were pumping at capacity, and they're in the process of identifying new well locations and don't intend to use this carryover or transfer water at this time until they've identified the new locations. So we could not conduct a material injury analysis and recommend it for approval, provided that once a new point of extraction or additional or a planned use of this water is identified, that a subsequent application is submitted. And the committee, the advisory committee recommended this application for approval. Are there any questions?
Any questions by anyone? Hearing no questions, public? No? Okay, is there a motion to approve R2537?
Motion. Oh, sorry.
Motion made by Brandon, second by Angelica. I appreciate your enthusiasm, Angelica. Keep it up so we can keep it moving. Is there any discussion? Hearing no discussion. Any discussion from the public? R2537 by roll call vote.
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandry?
Yes.
Director Martin?
Yes.
Director Paris?
Yes, motion's carried unanimously. We're now on R2538. Arden?
Thank you. So this is for a one-time transfer from RTS Orchards to Oro Vista Farms of 1,350 acre feet of carryover water. And so in January 2025, RTS Orchard transferred 1 acre foot per year to Oro Vista, and they intervened to become an Exhibit 4 party. So both parties are Exhibit 4 parties, and they are both using the same wells on the parcels from which RTS orchards were pumping for agricultural purposes as well. And we talked with Ora Vista, and they confirmed that the locations and volumes of the production will not change. So material injury will be negligible. And the advisory committee also unanimously recommended this application for approval. Any questions?
Any questions of Arden? Hearing no questions of Arden, any public comment, questions? Hearing none, is there a motion to approve R 2538?
So moved.
Motion made by Carolina. Is there a second?
Second.
Second. You missed it. And Helika, second by Kathy. Kathy. Yeah. Is there any other questions? Hearing no questions. All in favor of approving resolution R 2538 by roll call vote?
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandri?
Yes.
Director Martin?
Yes.
And Director Paris?
Yes. Motion's carried unanimously. We're now on item 14, consideration possible action on new production applications. That's going to be Arden. And first one is resolution R 2539, Arden.
Thank you. So this is for a new production application for Maria Ramirez. And this is for 3 acre-feet per year. So she has property in the Central Antelope sub-area, and this is for agricultural use. She has plans for a small plant nursery with about 4,000 plants in 5-gallon pots. And we confirmed the estimated water use, assuming about 0.6 gallons per day per pot, which is pretty conservative and leaves some wiggle room for the specifications that she provided. And there'd also be a small office. So in our material injury analysis, due to the low volume of water, we found the potential for material injury to be negligible. The advisory committee brought up that Ms. Ramirez owns a 23% interest in the property, and they wanted to ask Craig and the board to discuss the impacts on her minority interest in this application, and said in the notes that there's no known precedent for new production with a party who has a minority interest in the property.
Chair Paris, if I may, I can weigh in on that.
Great. Go ahead, Cameron. I was hoping you would.
The advisory committee does raise a legitimate concern, but before addressing that, I took the liberty of searching for this assessor's parcel number in our property search database, and I found 2 vesting deeds. One, and please understand our search database is not as reliable as a title report, but it tends to be pretty accurate, especially for more recent recorded instruments. The vesting deed that was attached to the application does show a 23.08% interest being conveyed to Samuel Flores and Maria de Los Angeles Ramirez as joint tenants. However, a second grant deed that was recorded on the same date from 3 other entities appears to have conveyed the remainder of the fee interest to those same 2 parties, Samuel Flores and Maria Ramirez. So based on our review, it does appear that she is the owner of 100% of fee title of this property as a joint tenant, in which case the advisory committee's concern shouldn't be an issue in this case.
Great. Good work. Thank you for doing that.
What percentage did you just say she owns now?
100% as a joint tenant with Samuel Flores, who I did not see on the application, but as a joint tenant, she should have the right to submit the application.
Yeah, well, it doesn't negate his responsibility, even
Correct.
if he's not on there.
I would take that position, yes.
That was the concerns of the advisory committee. And my comment was on that is, we had a case with the Derrick sisters. They had a well, it was active, just because they didn't know about the judgment and negate the responsibility to follow the judgment. So I'm fine with it.
I think the concern was that the only documentation that was submitted by the applicant showed her and the other joint tenant only owning 23% of the fee title, but they actually own collectively 100%. So we know who the owners are of this property.
Okay, great. Good work. Is there a motion to approve resolution R2539? Motion made by Kathy. Is there a second?
Yeah, second.
Second by Brandon. Is there any discussion? Hearing no discussion, all in favor of approving resolution R2539 by roll call vote?
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandri?
Yes.
Director Martin?
Yes.
Director Paris?
Yes, motion's carried unanimously. Now we're on item B and Arden, R2540.
Thank you. So this is the last new production application we have for consideration today. And this is for AV joint investment for 1 acre-foot per year. And they're requesting to drill a new well to supply water to 2 existing houses and specify that there would not be any irrigated landscaping. This is in the central Antelope sub-area. And this party would need to intervene to become a party to the judgment because they don't qualify as Willis class and are not a small pumper. We found the potential for material injury to be negligible because of the small volume, and the advisory committee unanimously recommended it for approval. Do y'all have any questions about this one?
Any questions, board? Any questions, public? Hearing none, is there a motion to approve R2540? Angelica?
Motion to approve.
Thank you. Is there a second? Second by Kathy. Is there any discussion? Hearing no discussion, all in favor of the motion to approve resolution R2540 by roll call vote?
Director McLaren?
Yes.
Director Hernandez?
Yes.
Director Calandri?
Yes.
Director Martin?
Yes.
Director Paris?
Yes. Motion's carried unanimously. We're now on item 15. The consideration possible action concerning selection of the WATERMASTer Administrator, and I think that's going to be a report by our General Counsel and or Water Engineer.
Thank you, Chair Paris. So everything that is included in your board packet starting at page 156 includes the universe of documentation that was prepared and sent out for this request for proposals process. It includes the actual RFP, the distribution list of all the parties who were sent copies of the RFP, and finally the only response to the RFP, which I'll qualify was not specifically identified as a response to the RFP, but rather a proposal submitted by AVAC as an alternative. No other responses were received to the RFP.
So where does that leave us?
General Counsel would need direction from the board as to which direction you would like to take with respect to the WATERMASTer Administrator, given that the only response was from AVAC.
And for the public, can you just summarize what AVAC's response was?
Sure. AVAC did not want to submit a formal response to the RFP, given that AVAC is not in the business of providing these administrative services and competing with the other professionals who would have potentially submitted responses. In the alternative, AVAC proposed continuing to provide services under the existing MOU.
Chair Paris, this issue is coming up, and I was concerned because the advisory board did not have time to weigh in on this issue. So yesterday, I spent a considerable amount of my time calling every single one of the members of the advisory committee and having a conversation with them about this issue. The responses that I got is 9 of them were in favor of just continuing forward with AVAC. I had 2 people that did not answer because one of them was a wrong number and wasn't available. And then one of the other advisory committee members said that he was good with AVAC continuing, but, did point out the procedural aspect that we have really set a precedent of going back and forth with the advisory committee and bringing issues of this matter before the advisory committee. So, but it is clear to me that the advisory committee's will is to continue on with AVAC. But I did want to at least hear from them before I had anything to say today.
Great. Thank you, Brendan. Any other comments? Public comments?
Yeah, this is Stan Powell.
Hi, Stan.
Yeah, so as a member of the advisory committee, I believe Brandon is describing my response. And I do think there's a procedural issue. However, I would also acknowledge at the end of the day, this is going to come back to this board to make a decision whether to continue AVAC in this position. So you have my input now that I would give at the advisory committee. So if you decide to proceed, I don't think you really have an issue with me. So I just wanted to clarify that. Thank you.
Great. Thank you, Stan. Any other comment by anyone? Cameron, what action, if any, can we take today, or what is your recommendation?
Just to respond to the procedural hiccup, so to speak, collectively with the Watermaster Engineer, General Counsel decided to extend the deadline for responses to give adequate time, which is the reason that the fact that no responses were received and AVAC's response, so to speak, was not included in the advisory committee's packet. So we apologize for that timing. We just wanted to give ample time for anybody to provide responses, prepare responses, and submit them. At this point, the board would need to make a collective decision whether to continue with AVAC under the existing MOU, continue with AVAC under some new terms, or propose an alternative.
Is your mic on? People are.
It is, yes. Sorry, I'll speak more directly into it. I don't know if Mr. Parton has any additional comments to those 3 options.
No, I think that accurately summarizes, Cameron, what the options to the board are.
And what was the date that it expired for RFPs?
It was July 16th, I believe, was the deadline.
Okay. And that was an extended deadline, correct?
Correct.
Okay. Board, your pleasure.
I mean, I think we need to hear board comment and hear public comment and make a decision.
This is Angelica.
Angelica, go ahead.
Well, I think at this point our options are there are no options pretty much. And AVAC has done a great job. I mean, we did our due diligence. We sent out the RFP, and that's it. But I think using the already existent MOU is not an issue. I just do have one concern regarding that MOU. In the term, this is an evergreen contract. I think it would be a better idea to have some kind of term, 2 years, 3 years, so that we can come back at that time frame and review and discuss instead of having that evergreen term.
Understood, Angelica. I'm going to ask Matt Knutson, the GM for AVAC, to come up and respond to that, and maybe respond to any other board questions about what AVAC's position is and we did have a discussion last night at our meeting, so I am aware, the public's aware, and Matt certainly is aware is the preference of the AVAC board. So why don't you let us know what your thoughts are and what the AVAC board preferences are.
Okay. May start with a phrase a wise man always says when he reports on the advisory committee, that the letter speaks for itself.
Is there trademark infringement on that?
Pretty clear. AVAC is willing to continue under the existing MOU, but we also discussed some benefits to having a specific term in the agreement. As I stated before, a term allows AVAC to plan a little bit more on staffing. We're not constantly in this limbo mode. So I think I can't speak for the AVAC board, but we did talk about being amenable to a specific term in the agreement. So if the WATERMASTER board wants to go down the route of amending or restating the MOU, the current MOU, and adding a term, that, you know, maybe the next step would be to direct general counsel of the WATERMASTER to work with myself on working through an amendment.
Matt, do you have any guidance? I mean, I hear clearly what you're saying on staffing and everything. Is there any guidance you can offer on what would work for AVAC? Or?
Well, last night at the AVAC board meeting, I threw out 3 years.
Mm-hmm.
For me, you know, as GM of AVAC, I think 3 years would be, it'd be good for planning purposes of staffing. And then looking at it from the WATERMASTER's point of view, I think 3 years gives a good amount of time to let the dust settle over this whole RFP and third-party consultant settle down, and maybe in 3 years we'll get more interest if the WATERMASTER wants to go back out with an RFP.
Well, man, I can't stress enough. I appreciate AVAC staff and the job that you guys have done and being willing to be there through some of these difficult times. Your staff has continued to operate in a truly humble, non-confrontational manner that has been here to serve its community, and you guys have a great reputation by example.
Thank you.
Thank you, Matt. And I think, any questions of Matt? Okay, I appreciate that.
Thank you.
And any public comment? Julie? This is Julie Kyle in person who's going to have a comment. Go ahead, Julie.
I appreciate AVAC being willing to hang in there with us and do the work. I understand that Matt's comfortable with 3 years and I'm comfortable with 5. So maybe we could meet in the middle. And this could go away for a while and we can focus on other things.
Well, if you add 5 and 3 together, that comes up to...
I'm great with that too.
Divided by 2.
Thank you.
Okay. Do we need a motion now, or can we even have a motion now?
At this point, I don't know if we need a motion. Well, a roll call motion would be sufficient for direction to general counsel to work with AVAC on an amended or restated MOU with a specified term. Does the board have specific direction on number of years?
I think 3 is minimum. I mean, I'm fine with 3.
So
3 years is good.
Go ahead, Annalena.
3 years makes sense.
I'd like to add a couple things. One, I want to echo Director Calandri's comments and appreciation for AVAC and AVAC staff. In addition, though, when there were, besides the term, there were other considerations for a potential change to the MOU. I think those should be included as well if we are going to consider a motion. And to opine on term, I'm comfortable with 3.
And then other conditions, you want to throw them out so that we can weigh in?
Yeah, I believe that at one point, Chair Parrish, you brought forth some proposals regarding safeguards to protect against not only conflict of interest, but perception of conflict of interest. And so I would like those to continue to be considered.
And I know one thing that we already implemented is taking Matt from being an alternate and now having other ABAC board members as alternates. That was one protection because Matt obviously supervises Peter. Our board only supervises Matt. So that's certainly one that we've already implemented. And let's talk about others that would make people comfortable. And Keith?
Yeah, I think if I'm remembering correctly, this Public Entity Steering Committee also asked for provisions related to some kind of accounting to make sure that the funds that were being collected from the administrative fee for WaterMaster were being used to pay for WaterMaster services as kind of a 218 type protection on the water rate side that the public entities are also paying. Did you follow me?
No. Elaborate a little bit more.
The concern is to make sure that AVEC doesn't accidentally end up subsidizing the WaterMaster from other funds that it's collecting from the public entities for water and other people for water service, and just to have some kind of annual review to make sure that all of the costs associated with AVEC doing the WaterMaster work are being covered and paid for by the existing administration fee.
I understand. AVAC, just if I am correct, is not subject to 218, but I understand the gist of that.
As much as it's a wholesale rate, you're right. But
yeah.
I guess you could say Prop 26, same principle that the cost of providing service is related.
That all costs of providing services should be passed on to WaterMaster.
Yeah.
Board. Yeah, I get that. You have questions of that, Cameron?
Yes, thank you, Chair Paris, directors. Earlier in this process, before the decision was made to go out for another request for proposals, General Counsel had worked with AVEC to generate a revised, amended and restated MOU, which I believe incorporated most, if not all of these terms. Those being setting a specific term, including safeguards to protect against potential or perceived conflicts of interest, and to address the accounting considerations that Mr. Lemieux just articulated. So if that's the direction from the board, we will work with Mr. Knudsen to revive that draft and bring it back for the board's consideration at the next meeting.
Very good. Consensus, board? I don't think we need
All those changes all need to be taken back to the advisory committee.
Yeah, correct. So let's work on a revised MOU, and I think we have a consensus for that. Implement our discussion today about all those factors. Work with Matt, we'll work with you guys to do that. Come up with a revised MOU that can be presented to the board and the advisory committee first, so we can get comments by everybody. And I think we have consensus for a 3-year term. And I think we've covered everything. Anything else from the public? You can do whatever you want, Julie. Come on up. This is Julie Kyle again.
And I know you're going to think I'm picking at this, but at that 3-year contract, can we have the 3 years start in 26? You know what I mean? I mean, we're through with 25. So let's go 26, 27, and 28.
Make it a calendar year.
Yes.
Wasn't there some problems that came up with it being a calendar year? I thought we had some discussions in the past.
Yeah, I think we should continue with consideration upon the date that this board opines that that's when we'll execute.
The reason I say that, Julie, we had discussions before because of when the money's collected in a change. Is that I can't remember the details of it, but I remember there was a reason why we wanted it that way
Yeah, Matt, if you
because
could-
of the way money's collected.
So public can hear.
I mean, Julie, theoretically, I absolutely agree with you, but there was a reason why not.
It's worked out.
I want a picture of this right here.
So, my recollection is that there were some issues with making a switch to a new third-party administrator in January 1st or on January 1st because of some of the invoicing and billing and things that have to occur at the beginning of the year. So we always try to accommodate have some overlap and have them start the first year of taking over, but they have some time in the role working under evac or side by side.
That's what it was.
Yeah. So I mean, I know we shook hands, but I'm with Director Hernandez that whenever we get at the MOU worked out, it's 3 years from that. And then if we go third party in 3 years, then we could always still provide that side by side work for 6 months or whatever. All right.
And this is what I love about the WATERMASTER Board. We can agree to disagree and be friends if I can say that. Okay. I think you have plenty of direction.
Thank you. Yes, we have our direction.
And Julie, who knows? May take that long to get it all approved. Stranger things have happened. Okay. We're through item 15. We're now on item 16. Consideration possible action on section 18515 of the judgment stormwater mitigation process.
Thank you.
Cameron.
This memorandum, which starts at page 178 of the board packet, was generated in response to a question that I understand was presented by Director Calandri at the last board meeting in June, requesting general counsel and the engineer to explain how projects within the basin are analyzed under paragraph 18.5.15 of the judgment with respect to projects that may impact storm flows that would otherwise recharge the basin. This memorandum summarizes general counsel's analysis in conjunction with the WATERMASTER engineer's take on the potential for projects to impact stormwater flows that may otherwise recharge the basin and makes a distinction based on the engineer's recommendation between stormwater diversion projects that are intended to prevent flooding, which typically do not result in permanent retention because the basins are not lined, versus stormwater collection projects, which are typically involve some version of a lined basin that does keep the stormwater and prevents it from percolating back into the groundwater, with the latter having a potential to negatively impact the basin, not the former. This discussion was purely hypothetical, so I would welcome further comment by the engineer and further comment by the board as to any specific projects that are of concern at the moment or that could arise in the future.
Arden?
Thank you. So I do just want to note that this focuses on the volume of water that would be recharged and the distinction between projects that would reduce the overall volume of recharge. And it came up in conversation later that this does not look at the distribution or changes of location of potential recharge within the basin.
So the question that I had when I brought it up was, we just have a section in the judgment that refers to, we're supposed to review this stuff, and I've never seen it happen before. So the question is this something we need to be doing, or is this something that we don't need to be doing? It's clearly stated in the judgment that we are supposed to be taking some type of action here, and I just want to make sure we're following everything that we're called to do. because while it's easy, agreed, it's the overall volume, but some of these stormwater lines can be as much as 6 to 10 miles worth of translocating water from one area of the basin to another through piping systems and canals, with great deal of changes in elevation. For example, from here to the fairgrounds is about a 500-foot drop in elevation. That's where a lot of the stormwater flows to, is adjacent to the fairgrounds. So the issue is do we need to take any type of action under this section to be having this stuff reviewed through these development projects? And a question.
Thank you, Director Calandri. And I will again welcome input from the engineer on a hydrogeological perspective. From a legal perspective, this conversation boils down to a cost-benefit analysis, to the extent the engineer should opine on whether stormwater conveyance projects that will eventually result in percolation back into the groundwater are worth the time and effort of the engineer to research and survey and investigate their impact on groundwater recharge. My understanding is that the engineer does not believe those types of projects have the potential to cause material injury or negatively impact the basin, in which case we wouldn't recommend taking any affirmative action. As recommended suggested at the end of this memo, there is the option to amend rules and regulations to place the burden on parties under the judgment who are planning or proposing these types of projects to submit documentation to the WATERMASTER for review. Although my understanding is the types of projects that do have the potential to negatively impact the basin based on the engineer's analysis are few and far between. But I will let Arden speak more specifically to that.
Thank you. So when we discussed this for this memo, we did find that it's unlikely that there will be projects that lead to a significant reduction of overall recharge, because typically stormwater is pretty contaminated and not actively used for domestic purposes, and it's hard to capture and store for other purposes. However, it did come up in my conversation with Director Calandri that projects that lead to a movement of potentially larger amounts of recharge could potentially shift the location of recharge within the basin. Not reduce the amount of recharge, but change the distribution a little bit. In general, this may not cause material injury, but it may be worth looking into to understand where that recharge might be moving and if there could be short-term or long-term impacts of it.
So what's your recommendation?
My recommendation would be, if we were to analyze this on a case-by-case basis, I would recommend that it's not coming out of the main budget for the WATERMASTER, because that's outside of the scope. But we would be able to work with the WATERMASTER to provide some reviews. I don't have specific recommendations on how the administrative process of how those projects are chosen or how that would exactly work.
So Arden, I have a question. And I just want to make sure that we have clarification, because I want to make sure that one, that the WATERMASTER is not overextending, and two, that there's real meaning behind this. If I read the memorandum prepared by yourself, the engineer, and council, and to reiterate Cameron's point that there is a feeling that this is not meaningful amounts of water, number one, and number two, that we have to make a determination if it's worth the cost to the WATERMASTER. And again, a third thing to point out that you said that these potential is very few and far between. So I'd like to point out that, and not totally hearing a clear recommendation from you, that this is not for consideration by this board for further investigation.
Yes, I don't have a strong recommendation that this is something that we need to consider. But if the board wants to look into particular projects or feel that it is important to examine, then we are happy to assist if it's required in the judgment.
I'm fine to move on. I just wanted to make sure we had a section of the judgment that we address everything as we're supposed to do.
And you don't see any need for any further action?
No, it was just plain and simple, a point in the judgment that had not been addressed or discussed, something that we're called to do, and we need to at least have it on record and clearly stated why. And, you know, we didn't have any input from the advisory committee on this either, but it was just a discussion point that needed to be had.
Yeah, so then with what you're saying, my only concern is if there's any others that might feel kind of like Brandon, it hasn't gone to the advisory committee. So should we give them at least a chance to weigh in on that? And putting it out to you guys, since you guys didn't even have a chance to see what Craig recommended in this discussion.
I think it's both Craig and, I just want to point out, and the engineer that are not recommending that.
Yeah,
be
well,
considered.
all the documentation sent to the advisory committee on the discussion.
We apologize for the timing of the memo, that it wasn't provided in time to be included in the advisory committee's packet. Given that this is not a particularly time-sensitive topic, one option would be for the board to include this exact same item with the same memorandum on the agenda and in the board packet for the August meeting, which would then be included in the advisory committee's packet.
Okay.
I have no problems with that. So, for our agenda, for our next meeting, Patty, just put it back on the agenda, and this memorandum will go through the advisory committee, and we can have another discussion if it warrants it after the advisory committee takes a look. Good idea. Okay, item 17, consideration possible action to direct Todd Groundwater to perform an analysis of the beginning basin balances by sub-area, and that's going to be a report by Arden.
So for this item, we included the memorandum that we had included previously, just sort of explaining our perspectives on if it is a worthwhile process for the WATERMASTer, and then we had included at the end what the process of evaluating the initial production rights by sub-area would entail, which would likely be an analysis of well locations when the judgment was entered, because several parties have wells in multiple sub-areas at that time, and there may have been changes in production through the years with different wells, and that would require looking into some of that past documentation. And we estimated that it would be about 25 hours or $6,000, the time to look into that.
Arden, the question I have is, I want to go back to that carryover by sub-area. So you guys are already doing estimates by sub-area, correct? That's the way I understood it a few minutes ago.
Yes, so we estimate the breakdown of carryover by sub-area currently. And when we provide that estimation for past years, it's still based off of the distribution of pumping by sub-area observed in the previous year. So
That could meet criteria of our sub-area management plan, correct?
I think it does a good enough job of just kind of showing how production rights have changed between parties through the years. It isn't going to give the exact numbers of what the distribution of production rights assigned by sub-area was at the beginning of the judgment, but it can give a pretty good estimate of what it is today, and then by who was pumping, and then going back and assuming that the parties, for example, who have wells in central and west sub area were pumping in the past at a similar distribution. If we really wanted to nail down the exact numbers, we would need to look into what the production prior to the judgment was of the different wells owned by the parties.
I'm fine, Chair Paris, I'm fine with removing or tabling whatever we need to do to pass this item up.
I think too that allowing her to do that would help to normalize the comparison that we initially asked for, or this board asked for, right? And so if she's able to do that and kind of, if we get separate presentations, we might not have that comparative ability. But with her presentation, I think she'd be more apt to provide us that comparative examples that we were looking for as a board when we made the initial request.
All right, any objections to Teresa coming back with the report?
None.
Okay, excellent. Thank you for the clarity.
We appreciate her doing it.
Exactly.
Will do. All right, and that concludes my report.
Great. Thank you, Peter. Now we're on item 19, WATERMASTER Engineers Report.
Thank you. This will be a very brief update. I'm going to share my screen real quick. All right, so we have our summary of new production and qualified small pumpers. And this is the same as it was last month. However, we do include, and this is item B in the agenda, we have a letter to mark a change in commercial to residential use for Mr. Arantes, who was a new production party. Originally, the water was proposed to use for a church, and he contacted us to say that instead they're going to use that water for a single family home residential, and did not find that this would have a significant change in the amount of water used or the recharge from water applied for this parcel. And so we have a short letter to summarize this. And this is just a reminder that these are things that we do keep track of. We don't charge parties an additional fee to update us about how they're using the water. We see it as part of our responsibility to keep track of if the use of water is changing in the basin. Are there any questions about this? Hearing none, that sums up the WaterMaster Engineer update.
Very good. And that brings us to the General Counsel report. And before we get to it, I have an announcement that I told a public member I would make and have a discussion about it and get input. Last meeting, there was a water transfer between AV Water Trust and California Compaction. My personal trust has an ownership interest in the AV Water Trust. I have disclosed that in a prior AVAC meeting and on all my political disclosures that I'm required to do. Based upon past discussions and direction by our attorney, I believe that there was no conflict with me voting on this transfer, and I did so. Recently, I heard a community member that I have a lot of respect for expressed a concern about that vote. I called the community member and let them know that I would bring this up at the next WATERMASTER meeting with the board and our attorney and express the concern and ask for clarification and direction. What I did not do is I had no involvement in the application process. I had no communication with the engineer, nor the advisory committee, nor board members. So I reviewed the prior memos written by our counsel to confirm in my mind that I made the right decision. I did ask, are we able to put those up? I had asked. Yes, I'd send an email requesting it, but so there's a September 18, 2019 memo that we had asked our attorneys to prepare. Yeah, I'd sent an email directly to Angel and Holly. That's one. There's one more. The first one is the September 18, 2019. Yes, that's the first one. And to me, the relevant part, but you know, everybody can read it and review it, is it says and it's right before the conclusion. If you want to, it's like the last paragraph and right before the conclusion. It says, in any other instance, i.e. when a landowner board member has material interest in a proposed decision or action, use of alternate members is feasible in eliminating any concerns regarding board members casting votes based upon self-interest. And I know Brandon routinely uses that method. And my feeling about it is that we require a 5-0 vote. The memos that are written are clear that we don't come under the requirements that I do under AVAC, and that disclosures in some ways makes it look like I'm trying to put my thumb on it. And I have not, I did not. It goes through the advisory committee. I think there's 11-0 vote there. And then in the second memorandum, and again, I have been voting for many, many years. I was the only last original member. We've been through these things. I have said to Brandon, I've said to John, I've said to others that because of the way we are structured, and we're structured by the court, and the advice that I've been given by the attorneys and the memorandums that I've read, I felt there was no conflict. And then, do you have that second memo up? Yeah, so go to 4 recommendation, or no, go right before 4 recommendation. And our attorneys wrote this, and it says recusal is necessary when a board member is disqualified, legally prohibited from participating in a vote as a matter of law, thereby removing the board member from participation in the matter entirely, and therefore not counting that member towards a quorum. In the context of public agencies, disqualification most often arises under the Political Reform Act, which is not applicable to the WaterMaster Board. When then is a WaterMaster Board member legally prohibited from voting? If a board member votes in a way that is intended to serve their own interest or the interest of a party they represent over the interest of the basin, this is a conflict of interest and should be brought to the court's attention. I have never voted in a way that conflicted with my responsibility for the basin. and I would never do that. I think anytime these things come up in the community, if they involve me or any of them, we should be transparent, discuss them in public, have a discussion with us. If we want to change how we do things, I'm open to that. But again, I'm not subject to the same thing, nor any of us. And we routinely make votes that would appear in another setting to be conflicts, such as today, Carolina and I voted on an AVAC transfer. I vote on things involving Brandon, who's a friend of mine, who we have dealings in public. I vote on other board members from AVAC's transfers, George Lane, Gary Van Dam. So I think, let's be transparent. That's what I did. I don't think I did anything wrong. If there's any member of the public that believes I did, or the board, let's talk about it.
Chair Paris, the times that I've recused myself has been in the cases of a direct familial relation. And I have fully acknowledged and appreciate those memos, and I agree with those memos. I did so just for, when it's a father to son transfer or a son to father transfer. I think that's a little bit different. I think it's appropriate for, as a landowner rep, I have no problems with what occurred with this at all. I understand it and agree with it. But I say that for the purposes of pointing out a difference. It was his choice.
And every time you do that, or when John did in the past, after we had our attorney weigh in, I've always said, you don't have to do that.
That's correct, 100%.
So, public comments? Board comments? Cameron or Craig, do you want to weigh in? Thank you. Oh, go ahead, Craig.
I just would say this is not an agendized item, and there's no action being sought to be approved, nor could there be today. If the board wanted to discuss this in public further, it can be agendized for the August board meeting.
Bless you. Board, any?
I feel no need to discuss this further. Chair.
And Helika, can you weigh in, please?
I agree with Carolyn.
Okay, thank you. And, I appreciate community input. I think this is the way things should be. And anytime, and I think from working with every one of these board members, anytime any of you think we've done something that we should open to the public, I am willing to do that. I think that's the way it's supposed to be. And please, anytime, call me direct, have that discussion. I think all of our board members are open to that. And anytime we need to discuss ethical or conflict issues, we should do it out in the open. And I don't know how many board members have been on here since our first memo was September 18, 2019. So I think this is always a good refresher. So thank you very much for your time. And Cameron, it's now your turn.
Thank you, Chair Paris. Just a couple items under the General Counsel's report. We addressed the advisory committee's comments on Rancho Sierra properties, specifically in the process. I think Craig was going to try and pull up the name of the appraiser that was.
Oh, sorry, Cameron, go ahead.
Do you have that name?
Yes, I do. The name of the appraisal firm that did the appraisal on the Rancho Sierra properties and developed a fair market value for the property is Volts, VOLTZ, Commercial Realty Advisors, and the principal of the firm, Scott Volts. just so Mr. Kyle has that information, and the public, for that matter.
Julie, if Galen's not on the line, can you give that to him? Thank you.
No problem.
Do we have any problem releasing that appraisal to?
I don't believe that would be an issue, and it would be a public record.
Yeah, I would think so
disclosure
too.
in any event. So
I think, again, as transparent as we possibly can be, we will release that appraisal. Is there a way we can add it to our agenda packet next time, or?
You know, the agenda, or you want it to be, based for, like, they put in a public request for information.
I'm open to anything.
I don't think we need to force them to put a public request in.
No, we'll just put in the agenda packet as a subject appraisal for any information, unless our attorneys feel differently.
that's fine for informational purposes. If you'd like to add an agenda item to next month's board meeting.
I would like
not
the
sure what
advisory
topic would be.
committee, I know there's a lot of comments in the advisory committee. I'd like the advisory committee to see the appraisal, weigh in if they want to, don't if they don't, and have it available for the public. So, you know, we have closed sessions, and there's things there's that tension between what we can discuss and what we can't discuss. And I think we've always, as a board, tried to give as much public information as we can with our attorney's advice of what we can't. If you're advising that the appraisal is not a problem to release and make public and have comments on, I think it should be agendized. But the other board members may have a different view.
I hear the spirit, but I'm more concerned of hearing from council about the appropriate process. I definitely think that it can be posted. Definitely welcome any public and advisory committee comment. I want to make a distinction between the fact that it needs to be agendized versus us being able to hear it, because I don't know that there's something for us to opine on from as a board any further. I want to make sure that there's understanding that this is a settled issue.
This is a settled issue.
And so if council can advise us on maybe the best way to post and be able to be transparent and hear from the public versus having to agendize it, I would appreciate that.
Sure. I think this is something that we may better address in closed session, which is our discussion about settlement negotiations with Rancho Sierra Properties, and make a decision on how to provide copy to the appraisal to the public, which I don't think is a problem, but it depends on what the board wants to do in terms of process. Like you mentioned, in terms of opening this back up for additional public comment, etc.
Good comment and Julie, come on up.
You're limping and we're making you walk down.
Yeah.
It's good physical therapy, right? Yeah.
Of the appraiser. I don't think it needs to go any further than that. Okay. I really don't. I'm speaking for him, but I'll take him on later. Thank you.
I'll bet on you.
Okay.
For transparency purposes, though, I think we can consider, and with council's blessing, of course, whether we can publish it still. I think it's still good for everybody to see the appraisal if that's appropriate.
Sure, we can continue that discussion during closed session.
Okay.
Good comments. Anything else?
The only updates on closed session items, which are matters of public record, in the Zamersla matter, which is currently subject in the Court of Appeal. Sherry Zamersla Greco Zamersla Greco has substituted in as the appellant in that case. And the Zamersla's reply brief is now due by August 6th. So that's still pending. In the WATERMASTER's litigation with Annette and Benny Moore, The Mr. Moore now represents Annette and Benny Moore. They no longer are represented by an attorney, and they filed a notice of appeal of the court's judgment in favor of the Watermaster on July 11th.
Okay. And do we have a need to go into closed session?
Yes, we do.
We do? Okay. You'll have to wait till next meeting, Benny. But thank you. Is there a motion to go into closed session?
So moved.
Motion to go into closed session. Second?
Second. Just a question for you. Julie was able to comment on Rancho Sierra.
Oh, good
If
point.
Benny's not able to comment on his, we let Julie comment. I think we need to let Mr. Moore comment.
Good.
If he has a comment.
Good observation. Benny, if you would like to make a comment to the board before we go into closed session.
I want to say that we're still trying to find out what to do and what not to do. We did apply for and set in motion for put meters on our wells, which was requested by the judge and what have you. But we have this is something that I'm told that the board should have heard. My case didn't have to go to court, or doesn't have to go to court. This is something that could have been brought out, all the documentation, and given to the board so they could see and possibly go to the advisory board. I mean, this is something that could have been brought out, and for some reason somebody wants to fight about it, instead of just look at the truth. So this is just what I want to say. But we are trying to do what's right. We're talking to the water resource boards, which is supposedly above this board, from my understanding. And their rules and regulations before this board came about, and this board is make a lot of different rules that kind of is a little bit different than the boards for pre-1914 rights and what have you. So to this board, it seems like they refuse to get into that, and that's what I want to say. But I am trying to get in line and do everything that is right for the state and the benefit of beneficial use for water for our aquifer. And I just want to bring that up. I mean, I'm not going to quit and just give up and lay down and not say or show what I've worked for that is written down and is correct and right. So I just want the attorneys to know that, and that's all I want to say. And I think the board should hear, just like they're hearing your point on your case. I have a case that is I'm not lying, stand up here just bringing up a bunch of stuff that's not true. I just want to bring it to the public and the board. And thank you for your time. If anyone have any questions, I'd be more than happy to answer.
Benny, we can't ask questions at this point, but I do always appreciate your professionalism. And anytime you've spoken in front of us, you've always been professional and polite, and I appreciate that. And Brandon, thank you for the reminder.
Yeah, and Benny, please don't take the lack of discussion as any sign of disrespect. We can't say anything.
So should we put this on something else on the agenda for next week or next month?
Benny, you're welcome to come and speak at any meetings. We will go into closed session. This is on the agenda in closed session. But you're always welcome to speak. Okay?
Okay.
Okay.
Well, thank you very much for your time.
No, thank you, sir. You take care. Now we have a motion to go into closed session. That has been seconded. All in favor of that motion by roll call vote? By roll call vote?
Director. That's okay. Director McLaren?
Aye.
Director Hernandez?
Aye.
Director Calandri?
Yes.
Director Martin?
Yes.
Director Paris?
Yes, motion's carried unanimously. And we will adjourn to closed session starting at noon. So I don't want to have any, no, I won't even say that. Okay.
Thank you, Chair.
Absolutely.